Right, good morning, everybody. It's 9:30, and I shall resume this inquiry into the appeal made by Blore Holmes and Paul and Linda Buckingham against the decision of Basildon Borough Council to refuse planning permission for a full planning application for residential development of 269 dwellings, use class C3, 2 vehicular access points off Dunton Road, formal and informal open space, hard and soft landscaping, including acoustic barrier and associated infrastructure. This is the final day of the inquiry. Usual reminders, please, mobile phones turned off or switched to silent. We will be shortly going through any housekeeping matters, and then we will discuss the Section 106 agreement this morning before moving on to the closing statements of the main parties. And we have a representative from Essex County Council as well, who's joining us remotely, which I shall come on to in a minute. Just to let you know, I am suffering slightly with my voice, so I shall do my best, but apologies if you can't hear. Please feel free to move forward. Do we have any housekeeping matters to address first?
There is. I should introduce Mr. Harding, by the way, who's the solicitor who's acting for the appellant in respect of the 106. We'll be addressing you on it in a minute. Yeah. You have received, hopefully, on, I don't know whether it was on Friday, but I think it was sent on Friday, the then agreed version of the 106 that had in it the new schedule that we've been talking about.
Yes, I did get that, yeah.
So that's a good start. However, there have been 2 or 3 small, but Mr. Harding's going to tell you how small, tweaks to it over the weekend that have resulted in a version that is still agreed, but that you've not actually got in front of you. I don't think, from what he tells me, but I'll pass over to him in a moment, it should prevent us getting, we're asking it to be printed right now, so you'll have it hopefully within minutes. It shouldn't stop us getting into, it doesn't affect any of the sort of substantive issues I suspect that you'll have with the 106. So shouldn't need to delay us, but just so you know, you're about to get a final tweaked version. And perhaps Mr. Harding could just, if you want to hear from him now on what the tweaks comprise, obviously you can
do that. We'll do when the document's here. That's fine. And the council have just given me a SIL compliance statement updated. So again, you can talk me through the changes they saw on that. Anything else? Mr. Dad's anything? No. Okay. So just so can I just take the name of the person who's online from, is it Essex County Council?
Good morning, Mom. You've actually got 2 people present from Essex County Council today. First, myself. I
can't hear you at the moment. I don't know if you can hear me. You can, okay.
Yeah, I can hear you.
Mark Lawrence.
Yep.
Yeah. Sorry, I can't hear you, so maybe we need to sort the sound out first. And it's saying Basildon Borough Council. Are you from Essex County Council? You are.
Ma'am, can you hear me?
It's not to do with the microphones in here, is it? We don't need to turn these off too. No. It's not to do with the microphones in here, is it? We don't need to turn these off too. No.
Perhaps if everyone could mute them their microphones as a starter. No, not you, madam. So I meant the people on the that's. Yeah.
I think that's because someone's got 2 devices on.
They all need to mute themselves. That's
that sometimes happens.
Okay. Can you hear me? Those of you online, the 2 representatives, if you've got another device that's turned on there, apparently it's causing interference. So can you make sure that any other mobiles or anything are turned off? Because it could be affecting the speaker system. And we're just trying to rectify it at the moment. You let me know if you can do some sort of signals, let me know when you've done that, and then we'll try again. We're just trying to rectify it at the moment.
That's working because we can hear them. That's what they
What would work? Sorry to.
Mark.
Can I just say one of the things that would work, if it might not be possible, but would be if the person from Essex were able to use headphones, that would work, because we wouldn't be getting the feedback loop, because his microphone wouldn't pick up the speakers. So I don't know whether that's technically possible at his end, but that would be an answer.
Ma'am, can you hear us now?
I still can't hear you, but I can see that you've put the headphones on. Still can't hear you, but I can see that you've put the headphones on. Oh, sorry, what's her name? What's the officer's name? Cook. Miss Cook, can you just try speaking again? No, can't hear you.
Inspector, if I can assist,
Yeah.
what we're seeing at the moment is the delayed broadcast by YouTube. That needs to be removed off the screen.
Okay.
And you need to go to the live feed, which we will all see instantly, because in a minute you're going to hear your voice, because we're looking at YouTube.
Okay.
Which is the
So what we're going to do is we're going to, I don't know if you heard that or not, apparently we're seeing a YouTube stream rather than the Zoom stream into the room. So we're going to remove ourselves from that, and then you will be reinstated via the Zoom, because we're watching a delayed version of you. Does that make sense? Okay, so we'll see you in a moment.
Hi, could you try speaking? We just want to do a sound check.
Good morning, ma'am.
Not audible.
Ma'am, would it be worth going old school and using a phone, perhaps broadcasting? Be hard to broadcast afterwards, I suppose.
Up to the council. Miss Cook, I don't know if you've heard what's happening. We're going to do a separate link between yourself, Mr. Lawrence, and the case officer at PINS. The case officer will forward that on to me. I will join the link. I will be able to see you. Hopefully you can see me on my computer, but your volume should come into the rest of the room like that. So we don't need the separate YouTube. Does that make sense? And then hopefully that short circuits and we can hear you both. Is Mr. Lawrence still on there? Can he? Yes, okay. So that
Yes,
should
ma'am, I'm
hopefully
here.
be through any moment now. So apologies for the delay. Sorry, yeah, we're not going to get any feedback. I'm checking. Can you hear me okay? Yes. Good. Okay. So let me just, what I'm going to probably do is turn you round so everybody else can see you and it's not just me that can. So can I just check? So you're from the, your infrastructure planning officer, Miss Cook, is that right?
Yeah, principal infrastructure planning officer.
Okay, and Mr. Lawrence?
I'm the strategic development engineer.
Okay, so I'll just do that now. I'll just turn my volume, make sure my volume's turned up. And then hopefully you could see everybody else, if that makes sense, or they can see you at least. Right, we've just, so we've got a slightly updated 106 from the one that I had issued on Friday and similar with the SIL schedule. So can you just talk me through the couple of changes on the 106 to start with and then the SIL schedule?
Morning, thank you.
Morning.
The amendments to the Section 106 agreement since the previous draft from Friday include an amendment to clause 5 regarding the trigger for payment of the monitoring fees to the council and county council. Rather than on completion of the deed, monitoring fees should now be paid within 10 working days of the grant of planning permission. And the other...
Sorry, that's the county council, did you say?
So, sorry, county council and council.
And council, okay. Within 10 days.
And the other amendment is to schedule 5 of the Section 106 agreement to include a new paragraph 10, which includes a paragraph stating that in the event that all or any part of the open space culture for play and sports contribution has not been spent or allocated within 10 years from the date of payment, then any unspent part of the contribution will be returned to the party who paid it.
And sorry, have I got a printed copy of this?
I think the printed copies are on the way. They've been printed this morning.
Okay, that's noted. And on the changes on the SIL schedule, what are they?
There's just been a schedule 10 has been added to sections 3 and 4 to reflect the western boundary treatment elements that were added to the draft section 106, and the county council obligations have been updated again, I think, to reflect any changes to the section 106.
Okay, who can talk me through the changes on the county council?
That would be Mark Lawrence and Anne Cook.
Are you able to do that, Mr. Lawrence or Miss Cook? I've got an updated copy of the SIL schedule here. I just need to know what the how that's changed from the version that I've had.
Yes, Mark, I'm just opening the document in front of me. Can you hear me okay?
Yes, we can, yeah.
Yep, lovely, thank you. Yes, it was just to update the SIL compliance document in line with the 106 as being described, which is inclusion of the other highway works elements within Schedule 6, and that's primarily what it is within that document.
Schedule 6. Okay. Okay, and I'm just going to go through the headline figures as I have them based on the 106 as issued on Friday. So in terms of Basildon Borough Council, I have the employment and skills contribution at 80,700. The NHS healthcare it's 133,300. The open space, culture and play space at 448,761. And then I have the Essex County Council contributions, the 2 schools contributions at the primary education and the secondary education figures as identified. And can I just clarify, there seems to be reference within the document to sustainable transport contribution and bus contribution. Can you just clarify, because somebody just clarify what the difference is? I think they're one and the same, but why is both terminology used is my question.
I think so. In previous drafts, the cycleway and public rights of way improvements were originally to be delivered through a contribution and were part of a sustainable transport contribution, but those have been moved to be carried out under the Highway Works agreement as part of the Highway Works, and so I think it's just a hangover from the previous draft that there's still the definition of sustainable transport contribution.
Okay, and then I have the residential travel plan monitoring fee at 1596. I think that's slightly different on your sales schedule, is that? The figure is expressed on the sales schedule.
I'm not sure why that figure is different. Are you suggesting that it's a different figure within the section 106 to what we've got reflected in the SIL statement?
Yeah, so the SIL statement says 1533 and the 106, I mean, it's not much, just 1596.
So, Mark, are you able to clarify that change? Because the 1533 is when we had the original section 106 before it was changed. So has it changed since you made any amendments to it, that figure?
Leave that one with me, as it's a typo in the numbers, but I'll just double check whilst we're chatting.
Okay, thank you.
And the monitoring fee for the county council is at £550 per obligation, so 2,200 in total, and the Basildon Borough Council monitoring fee at 26,900. The travel vouchers, is that sufficiently defined within the document? As it is, as in what that entails, this was my question.
Sorry, Madam, do you have any particular concerns about the definition?
Yeah. Is it sufficiently defined? Is it? I think it's on. I've got noted down page 56. Is that on the PDF page 56? I can't look at it.
Yeah, still page 56.
Just to confirm from Essex County Council's perspective on page 56 regarding the travel vouchers and the description, those are our standard wordings.
Oh, is it? Is it? Okay.
Just to confirm on the difference between which has been approached in this one is that there's a quarter season ticket that's being suggested, which is over and above our usual six day ticket.
Yeah, I suppose it was, is it sufficient? Yeah, I mean, I don't know how to, I'm just phrasing it in exactly the same way. Is it sufficiently defined in terms of the actual value? Is it sufficiently clear as to what that is from the definition? A quarter season ticket voucher for the Basildon Plus bus or similar ticket. I mean, if the answer is yes, you're all content that it's sufficiently defined, then that's the answer.
We're happy with it, Essex County Council, Mum.
I think so Mr. Lawrence can correct me if I'm wrong, but I think the value of a quarter season ticket is listed on the Basildon Plus bus or the Essex County Council website.
I couldn't give you a definitive answer on that one. It's not a website that I've visited to confirm the price of the tickets.
And then in terms of the housing, the open market housing as defined within the document is 161 dwellings, and the affordable housing total is at 108 dwellings with the split as defined. Could you just talk me through Schedule 10 and the western boundary and how that's been addressed? Because obviously that's something new that's evolved. So have we got the hard copy of the one that's coming through? Because I can't access the... I can't access it, yeah. Does anybody have a printed copy of the updated 106? Okay, I'm going to have to access the document on my computer, Ms. Lawrence, Mr. Lawrence and Miss Cook. Is that possible? So I just have to minimise you. Is that okay?
By all means.
Yeah. Right, so I've got the document as sent this morning. What page is the open space addressed on? Schedule 10?
The Schedule 10, 68.
And just talk me through the changes.
So Schedule 10 is a new schedule that's inputted towards the end of last week, which relates to additional landscaping along the western boundary in the area shaded blue on the plan to be appended to the Section 106 agreement.
Yeah.
So prior to the commencement of the development, the developer is to submit, so the owner is to submit a specification setting out the details of the western boundary treatment and a proposed management plan relating to the ongoing maintenance of western boundary treatment. The western boundary treatment works to be provided in accordance with the specification and management plan are to be provided prior to the occupation of more than 75% of the total number of dwellings in development, and a contract for the transfer of the boundary treatment is to be entered into with the management company.
And the management company would work in a similar manner as the other open space, is that right?
That's correct. Yeah, it's the same management company that will be maintaining the rest of the open space in the development.
Okay. Again, can we just turn up the SIL schedule? Sorry, can I just clarify, is there anything else on the totality of the contributions that anybody needs to update on other than the figures that I've summarised? No. Okay. So if we just pull up the SIL schedule. You're back on now, both of you. So I'll have to use the old one because that's the one that I've prepped on. So from 4.4 onwards on the SIL compliance schedule, you've gone through the requirements in terms of Basildon Borough Council. Can I just see if any on the healthcare contribution, is there an actual facility specified? It just says in the vicinity of the application site.
In terms of the request we got, that they tend to leave it open so it covers more than one surgery. So it would be within a certain surgery that covers that ward. So it can be more than one surgery at a time. So that's the normal wording they use now.
Okay, but they haven't actually specified, you say can be more than one. They haven't actually, it just says, in my version, it says in the vicinity. So they haven't specified beyond.
That's correct, ma'am. It's standard wording they're using now for obligations that we're dealing with. And it doesn't state a specific surgery. It just uses in vicinity of, which allows them to look at alterations to more than one surgery in the area.
Okay, and then on the open space culture and sports, play and sports contribution, that is specified in terms of the Steeple View open space upgrade, the Willow Fields open space and the Noak Bridge. Is that right?
That's correct, ma'am.
Yeah. And then on the schools provision, just talk me through the schools envisaged in terms of the primary and the secondary contributions. I know that there's no contribution required for the early years childcare.
The figures are calculated based on the formula that's set out in Developer Guide for Infrastructure Contributions. So we have a set formula that we use to calculate the number of units and the pupils that are created from those types of units, and then by the cost per place, applying the cost per place that's live at the time we do the calculation gives us the contribution figure.
Yeah, and then the schools that it's envisaged that it would go towards?
We look within a 3-mile radius of the development. That's the hopefully a walkable distance, a reasonable distance from the development for the children to go to school.
This is on primary? This
is on primary. We look, it's the calculation that's assessed by our school place planning manager. They look within the 3-mile radius of the development. So that gives them the scope to spend the money on expanding schools within that area. The secondary contribution covers a wider field, 3-mile radius, which is the capture for the contribution spend.
Sorry, the secondary is a wider area.
But we calculate the need within a 3-mile radius. well, the actual spend, the actual purpose, we're asking for the contribution to be used for the delivery of provisional facilities within a 3 mile radius, or a facility that the council best serves the development. So it would be wider than 3 mile radius if that fitted the need, where the children would go to school. Secondary schools tend to be lesser in numbers, so the children would have to travel further to get to those.
Okay. And I see that the bus contribution is as defined. I don't have any particular questions on how that's set out. Does anybody else have anything to raise in terms of the 106 agreement?
Nothing from us, Madam.
Okay, sorry, I didn't get a note of your name actually.
Sorry, it's Nick Harding from Gowling WLG.
Harding?
Yes.
Sorry, the company name?
Gowling WLG UK LLP.
Sorry, Mr. Harding's a senior associate at Gowling, GOWLING, and then second word, capital W, capital L, capital G.
Gowling.
Gowling, so
Yeah.
that's capital G, and then OWLING. So the word, so Gowling, and then second word is 3 capital letters. Gowling, WLG.
Okay. So no further questions from anybody on the 106 agreement.
Ma'am, if I just may clarify that single point you asked me to check on earlier regarding the monitoring contribution regarding the travel plan. I can confirm it is 1,596, which is aligned with the section 106 agreement. It's the SIL that will need amending, SIL statement.
Okay, thank you for that, Mr. Lawrence. As I was here, Mr. Daz first.
Madam, we just asked if we could have an up-to-date 106 agreement, because we had one on Friday, but we've not been sent one. But we make no further comment. We've said all along we will just let the council do that need, but we'd like a copy.
Have you had it emailed on the updated one?
I haven't seen one at all. Okay.
No. You need to be, so we'll do it.
Somebody will do that now.
Ma'am, it's Michelle Hock from the council, senior planning lawyer. It was just to say that we are intended to make a minor tweak to Schedule 10, the definition of the western boundary specification, something to the effect to ensure that the space is used for public use. We're just in the process of agreeing it with Mr. Harding.
Okay, noted that. Is your surname H-O-C-K?
Unusual, it's H-O-Q-U-E.
Have I checked?
Thank you.
Okay. So can I just talk time frame for the finalised 106 then, please?
Probably more down to the authorities, plural, than us. I think from our side of it, it can be done quickly. It's just a question of sealing days and that kind of thing. Just 14 days to do it. I don't know whether the county have any particular.
Do you have any? We're just trying to agree a time frame for the submission of the final document to the inspectorate.
I'm certain, Mum, from memory from our end, our usual signing days are Wednesdays, and they nod. Yeah, So I thought, Wednesdays are our usual sealing days at the county. From our perspective, well, from Highway's perspective, I'm quite happy with everything in there. I can action my legal team accordingly.
Sounds like 14 days, madam, would suit everybody if that's
So 14, sorry, I can't access my calendar, so 14 days.
So today is Tuesday the 21st. It would be Tuesday, 2 Tuesdays' time, it would be Tuesday the 5th of December.
Tuesday the 5th of December.
Excuse me, ma'am, would it be better to put that onto a Thursday so that we give ourselves an extra Wednesday to get sealed in case we don't get it sealed next week?
Yeah, I was just
Something the
thinking
day
that's
before our signing day, so would that be possible?
Not a bad idea.
Thank you.
So that's Thursday the 7th.
Thursday the 7th of December would that be 2 weeks plus 2 days?
Okay.
Ma'am, sorry to be tedious. If the county council end up sealing on the 6th, I'd probably suggest that we give ourselves an extra day for those documents to then come to the council for us to execute the documents as well.
Okay.
That would be Friday the 8th of December.
Yeah, I think Friday the 8th would be safer.
The other takers.
Okay. And just so for everybody's benefit, there is no extension on that time frame. That is set today, and that is it. So there's no coming back saying we've missed it. Can we have an extension? There is no extension on that date. So Friday the 8th of December.
Thank you.
Okay, thank you. I think that probably concludes the requirements of Essex County Council to continue participating, unless you want to stay on the line and listen to the closing submissions of the parties, but I think you can do that in another method. So thank you very much for your contributions.
Thank you, ma'am. Thank you for your patience this morning.
Thank you.
To sort things out.
Thank you.
Bye-bye.
So should we have a short adjournment?
Excuse me, can I ask that if everybody can, so we've managed, the printing won't be resolved. There's a problem with Canon's Cloud and we don't know an end date for that. If people want to, if the appellant, the Rule 6 party, want to email Gordon their closing, then we can get it copied. We've got a satellite office in town that we can get it copied from, so we can get them printed, but it will probably take us about 20 minutes.
Okay.
I have already.
Yeah.
And I have a couple.
Okay.
Just for our part, thank you for the offer. That's obviously very generous of you to suggest doing it that way. The difficulty that I've got is that ours won't be final. I mean, we've written them obviously until we've heard everyone else. So options include we either I don't know the extent to which you'd be prepared to take it, as it were, on your screen as a PDF for today, sort of thing, rather than a hard copy printout of my closings, which would be one way forward. The alternative would have to be that if it's a 20-minute delay or whatever, then after Ms. Ollie and then Mr. Dad, we'd have to break again I'd email the PDF as soon as I can to whoever it is, and then we'd have to break for them to go and print it off in town.
Yeah, I'm content to read off the screen, but it's just whether other parties are.
Oh, I see. Obviously, I could email it to Mr. Dad's. We could get it. Presumably, we could get it up on the internet pretty quickly if we could get it on the website. So if you were happy with that, and we'd get it on the website, and obviously then people can print it off in due course, kind of thing.
I'm content with that, because what I would normally do in any event, this is setting out what I believe, and then not ordinary. If I'm in Mr. Simon's position, I would just amplify and add a few things to it. So if he sends me a copy electronically,
yeah,
but I can't obviously have it.
Sure. So if everyone's happy with that, then I'll just do ours rather than printing ours out. I'll just circulate ours. Thank you so much. I'll circulate ours when the time comes electronically through to the case.
And we'll just have a pause and
pause to make sure you've got it, and I'll just read it out. Thank you.
Okay.
Emails mine to the inspectorate. Did you say Alison Dyson?
Yes.
Okay.
I wouldn't know because they're all encrypted. I know I've already asked about this, but can I just confirm there are no applications for costs?
No.
Do you want to have a short adjournment so the council can get themselves together too? Yeah, okay. Well, it's 10:20, 10:25, so we'll just have a short adjournment to 10:35. The inquiry's adjourned. Okay, it's 10:35, so the inquiry is resumed. Mr. Humphreys, I've received the updated SIL with that typo rectified, so thank you very much for that. So the council, that we'll be hearing from the council on their, in terms of their closing statement, then the Rule 6, and then the appellant. The hard copy of this will be uploaded onto the core documents list if you want to be able to access it from there. So over to you, Ms. Ollie.
Thank you. Introduction and the planning balance. The ultimate question for the inspector in this appeal is whether the benefits that the appeal scheme presents clearly outweigh the harms. So in this case, that means, do the benefits, of which the key ones are the provision of 269 new houses, 40% of which are to be affordable homes, outweigh the harm to the green belt and the fact that if the council's case is accepted, the site's location or sustainability is inadequate. In his analysis, as set out in his written evidence, Mr. Hargis found that the matters in the planning balance were finely balanced. At the very least, that explains how it could be the case that the council's officers were satisfied with the scheme, but the elected members were not. In such a case as this, certainly, both conclusions can be possible. In line with his professional duty as an expert witness, Mr. Hargis considered during the course of the inquiry whether the needle had moved at all in either direction, and explained that depending on what eventual conclusion the inspector arrived at in respect of the greenbelt harms, the balance might tip slightly in favour of the scheme. What he was clear about, however, was that even if that were the case, the balance had not radically shifted in favour. The benefits still did not clearly outweigh the harms. The appeal therefore falls to be dismissed. As Mr. Hargis said, it's worth reminding ourselves of the MPPF test. Very special circumstances will not exist unless the potential harm to the green belt by reason of inappropriateness is clearly outweighed by other considerations. Clearly is the critical word here. I commend Mr. Hargis' evidence to you. It submitted that it was sincere, well thought out, fair, reasonable, and balanced. Likewise, Mr. Fisher assisted by identifying the areas in which the position between Mr. Hargis and himself had narrowed or been illuminated during the course of the inquiry. Bar one or two examples of varying recollections, those were accepted. The inquiry has heard that this local planning authority does not have a 5-year housing land supply. Indeed, that it is very low, only up to 1.85 years on current figures. Housing shortfall is prevalent throughout the country. We have a nationwide problem. The challenge presently is how to approach the resolution of an individual case in which those universal issues apply. Mr. Hargis summarised in chief his approach to what lies in the balance. What we have in favour is a substantial shortfall in housing attracting substantial weight, and that has to be acknowledged. The other matters are of limited weight. The economic benefits are very limited. They will add about 0.1% to the GDP of Basildon. That's the nature of the benefit we are talking about. It is minuscule. So there are matters in favour and against. In relation to the identified harms to the green belts, the first key main issue, the parties are in agreement that those must be afforded substantial weight in the planning balance. In the overall planning balance, the nuancing of weight will depend on exactly how much harm there is considered to be. In relation to the other key main issue, the sustainability of the site's location, it may be that the lived experience of the current nearby residents, many of whom have attended to speak at the inquiry and who are otherwise represented by the Rule 6 party, is found to win out over any more theoretical modelling, which it is submitted does not ultimately mean much if it is contradicted by the evidence of what is happening and likely to happen in practice. The council can raise issues on the basis of common sense and logic, but the best test is practical experience. One particular example stands out. Mr. Scott Gibson of Greengage Cottage on Dunton Road confirmed that he works half a mile away from home, that he would never consider walking there. He did try cycling once, but nearly got knocked off his bike on the way home. That is the reality that the inquiry has heard. Main issue, the effect of the proposal on the openness of the green belt and the purposes of including land within it. The parties are agreed that if the proposal proceeds, there will be at least limited harm to the green belt. Both the council and appellants use the assessment of potential visual effects included within the submitted Livia and the Place Services LVIR as a starting point to determine the impact on visual openness. It's acknowledged that localised harm would arise at both year 1 and year 15, but there's disagreement on the level of contribution that the site makes to Greenbelt purposes. The appellant asserts that the appeal site will make a limited contribution to purposes 1 and 3. Mr. Chard agreed that his reasons for finding only limited harm were, in the case of purpose 1, first, the built form around the site. Secondly, that the development would not result in the built form of Basildon extending any further north or west than the current established limits. And thirdly, the landscape mitigation strategy. In relation to purpose 3, his reasons were 1, that the site has greater affinity with the urban edge of Basildon than with the open countryside to the north, a point to which we will return. And 2, that the adverse effects of the development will be mitigated. Mr. Chard finds a spatial loss of openness, but considers that to be limited by the scale of the development. In other words, its height at 2 to 2.5 stories only, and the fact that that is not uncharacteristic of the area, and the retention of open spaces throughout. There is nothing between the parties as to the substantial weight that any harm to the Greenbelt should be afforded in the planning balance, even if it is not ultimately accepted that the harm would be substantial rather than limited. It is probable that it is in fact somewhere in between the two. Nonetheless, it is submitted that the harms are not only limited. On the council's case, the site comprises a markedly open and undeveloped field in the rural countryside, lying to the northern and western edge of the built-up area of Basildon. It clearly plays an important role in preventing sprawl and safeguarding the countryside from encroachment. The site's characteristics, as relevant to considering harm to the openness of the green belt, include the panoramic views to the north, the sense of separation between Billericay and Basildon, the long-distance open views across the upper Crouch Valley towards Little Bursted, the fragmented roadside hedgerow along Dunton Road, clear views towards the site from local rights of way, the A127 corridor and mature vegetation on the Ford Research Development site, which create a strong sense of separation from Basildon. Indeed, there is an identifiable sense of separation to the north created by Dunton Road, and the A127 also creates that by virtue of being an even more durable and robust boundary, as judged in the council's case. Dunton Road is an unclassified road with a ditch and fragmented hedgerow vegetation. If we accept the view that it forms a robust northern boundary, surely we must also accept the role that the A127 corridor plays in preventing urban sprawl from the south. The A127 is an additional barrier for the green belt. It is said by Mr. Chard that the site does not offer any public access and does not offer any recreational opportunities, but that is to consider one dimension only. While the site itself is not publicly accessible, the public right-of-way abuts the entire western boundary, north from Dunton Road to Little Bursted, and there is also the footpath, less than 200 metres to the east of the site from Dunton Road, running north to Great Bursted. The agricultural landscape forms part of the view on these routes and is surely important to the enjoyment of recreational activity, walking, dog walking, exercise. It's hard to see how the experience of new residential development would be an improvement to the enjoyment of the views within this landscape, however high quality that development may be. There appear to be internal contradictions in the appellant's case when arguing on the one hand that the identified long views to the north and northeast cannot be appreciated from the eastern part of the site, with the exception of brief views from the A127 in vehicles travelling at speed, such that there are long views to the north and northeast from the north and northwest parts of the site only, and saying also that when travelling west along Dunton Road from Kings Road to the east, the existing residential development looks north over open agricultural land. Clearly, there would be views from the upper parts of properties across the open arable fields and long distance views by residents along Steeple View. Although it is said that at no point is the site seen in its entirety due to physical containment, the site is actually highly visible across both its parts, particularly from the A127. Woodland does filter views to the northeast portion, but the southeast portion is far more open. The sloping landform of the site allows intervisibility between the open farmland of the site, the River Crouch Valley beyond, and towards the spire of the Grade 2-star listed St Mary the Virgin Church in Little Bursted. The visual extent of the appeal scheme can be seen in the appellant's viewpoint photographs, 12, 15, 17, 18, 19, at up to approximately 2.2 kilometres from the site. The ultimate judgment can and will only really be made on a site view. That is classically the case in landscape and visual matters in planning and when making a judgment on openness. It is again suggested by the appellant that the proposed landscape buffer will limit intervisibility between the site and the sensitive visual receptors to the north, including the church, although it is simultaneously argued that the landscape strategy will be retaining views towards the elevated land to the northwestern church. It is also stated that the eastern parcel of the site is well enclosed by residential development to the east, but as can be seen from CD 2.1b, from the tree survey and AIA, there is in fact a fragmented and gappy tree line and hedgerow. The significance of this is that when a built edge is predominantly irregular or the boundary composed of less durable features, the green belt will play an important role in preventing sprawl. This is relevant also to the western parcel of the site. The western boundary is set back from Steepleview Farm on its access track, and that's undefined. It's actually left as an open field strip with no landscaping. It's hard to reconcile that with the appellant's statement that the site is located and perceived within the context of the urban edge of Basildon. Next, there is clearly a significant overstatement in the appellant's case and its description of so-called ribbon development to the north of the eastern parcel of the site. In reality, this consists of Greengage Cottage, 1 and 2 Whelps Cottage, and Briar Cottage. They inset the north-northeast boundary of the site and are separated by intervening trees and hedgerow vegetation. It could be called intermittent development or scattered. It is not ribbon development. The appellant makes much of the green gateway to which it refers and the generous offering of green space, including within this the fact that the northwest corner of the site has been left as open space. Of course, as the appellant says, that is because of the power lines there. So this is in truth a mitigation measure to try to reduce harm and is based on the constraints of the site. It is submitted that the site already functions as an attractive green gateway to Steepleview and the green belt, and it is unclear how more residential development will provide a green gateway. Nor is it accepted that the mere retention of existing features is a benefit. Similarly, setting housing back is not a benefit of the scheme, but rather a mitigation measure to try and reduce the harm. Significant weakness in the appellant's case is the reduction of openness that is necessarily created by the landscape mitigation, including the substantial landscape buffers. Reduction of openness means harm to the green belt, which in this case is substantial, not limited. By way of further comment, the amount of landscape buffer required reflects that this has indeed been a constraint-led design as opposed to a landscape-led approach. The proposed landscape features such as the bunding and acoustic fencing along the southern boundary would do nothing to offset or maintain adverse effects, but on the contrary, would serve to emphasise the permanent loss of openness and the substantial harm to the green belt. I think I should say contain, sorry, not maintain. As noted above, Mr. Chard accepts the impact on the spatial openness of the green belt. However, again, the harm is not as limited as the appellant presents. On the 9.5 hectares site, 7.39 hectares will consist of built development, representing westwards and northwards encroachment of urban character. And it is no answer to say that some or much of that will be gardens and driveways which are inherently open. In reality, that means garden plots, driveways, parking of cars, fencing, lighting, other domestic paraphernalia. Further, these are essential elements of an urban landscape. On this basis, there will be a substantial, not just limited, loss of spatial openness associated with the proposed development. Whilst Mr. Chard argues that the majority of the buildings will be two-storey, thus of a scale appropriate to and not uncharacteristic of the surrounding area, this hardly mitigates the damage to spatial openness caused by the development, as opposed to being relevant to the wholly different point of character and appearance. Permanent built form at 2 to 2.5 stories, stretching across the majority of the site, will plainly erode openness compared to the existing open character of the site and green belt. It would not be right to downplay that. The substantial landscape buffers, which will increase the physical containment of the site, mean also that the visual perception of enclosure will significantly increase. The views referred to in Table 1 of Mr. Chard's proof, called perceptual harm to openness, are not merely limited or local. Viewpoint 19 is about 2,200 metres from the edge of the site. Viewpoint 18, 2,100, 1,700, let's say 1,700 metres. Viewpoint 15, 1,200 metres, and viewpoint 12 920 metres. The fact that the development only forms a small part of the overall view is a function of how distant those viewpoints are. In any case, these are relatively extensive views. The effect of the development in terms of perception of openness will be quite extensive to the northwest. There will be a reduction in openness for local views, but also the middle distances. In viewpoint 11, 500 metres to the northwest, in places we have clear views of the site along the length of Rectory Road and the public right-of-way north of the site. The site provides an important function in both spatial and visual openness, containing development sprawl from the south into the open countryside. Most of the site is open with a wide visual envelope. It will no doubt have been seen on the site visit how markedly open the site currently is. The new development would result in visual and physical intrusion into the open countryside, creating an incursion of urban sprawl between the rural farmstead at Steepleview Farm and the rear gardens of dwellings along King's Road. Thus, the harms are not simply limited. Mr. Lewis explained in cross-examination that within Appendix 1 of the LVIR undertaken for this site, there is a list of recommendations that set out how the design could be improved to help alleviate and mitigate the harm to openness, but they had not been taken. Mr. Richards was criticised, it seems fair to say, in cross-examination for using the wider Area 20 parcel, which includes the site, in his analysis, although it's equally fair to say that Mr. Chard placed a lot of emphasis on the 2013 study, see his table 7.2, which of course concerned Area 20. It is submitted that the point may ultimately be something of a red herring. Mr. Chard was asked in chief why it would be better to do a site-specific assessment rather than a wider one, and said, you should look at the site itself. Otherwise, the contribution of the site to the green belt is going to be smaller in looking at a wider parcel of a far larger area. So you need to zoom down to how the site contributes to that wider parcel. In fact, therefore, if Mr. Richards is to be criticised, it can only be for not presenting an even stronger case. On the appellant's approach, as explained by Mr. Chard, to look at a wider parcel may be to risk diluting, not exaggerating, the impacts that one may find. In any case, as submitted, the site does play more than a merely limited role in relation to purposes 1 and 3, and has more than a merely limited impact on both spatial and perceptual openness. The presence of a robust physical feature does not mean that the contribution of a site to a greenbelt purpose is limited. See tables 7.4 and 7.5 of Mr. Chard's evidence. The A127 may be perceived as a robust barrier, but also as strongly defining a permanent boundary which prevents sprawl from the south, with the greenbelt further functioning as an additional barrier to sprawl. The site contributes much more strongly to purpose 1 than Mr. Chard judges. It was indeed an odd point to make at table 7.4, page 45, in the context of an assessment relevant to the greenbelt, that there is a clear precedent for development to the south of Dunton Road. There would be a cumulative impact of development on sprawl in the countryside. In relation to purpose 3, Mr. Chard made the point that there are already residential neighbourhoods to the east and along Dunton Road. Again, such a point seems more relevant instead to any issue of character and appearance. Mr. Chard accepted that in cross-examination. A golden thread running throughout Mr. Chard's evidence is the assertion, appearing about 7 times, that the site has a greater affinity with the built-up urban edge of Basildon than with the open countryside extending to the northwest of the site. That is highly subjective. As put to Mr. Chard in cross-examination, it really depends on which way one is facing. For the reasons above, the appeal proposals conflict with the NPPF as they are not sympathetic to the essential characteristics of the Greenbelt's permanence and openness. To allow the appeal would undermine purposes 1 and 3. Main issue, whether the site is in a location which is or can be made sustainable. Simply, it is not. Mr. Hargis draws our attention to the fact that the site is in a remote position off a narrow rural lane, constrained by the A127 to the south, served by infrequent bus services, not readily accessible to local shops, amenities or services, and that there are limited opportunities to improve pedestrian and cycle links. It is clear from the Essex Design Guide, CD 8.8, to which Mr. Hargis draws attention, that development should be laid out to maximise proximity to facilities and public transport and to encourage walking and cycling instead of driving. The guide states that no part of a residential area should be farther than 400 metres from a regular bus route, 600 metres from a primary school, or 1,500 metres from a secondary school. The IHT providing for journeys on foot, quoted in the appellant's transport assessment, explains desirable, acceptable and preferred maximum distances, 400 to 500 metres, 800 to 1,000 metres, and 1,200 to 2,000 metres respectively. An 800 metre or 20 minutes walking distance is considered comfortably accessible, DFT manual for streets and TCPA 20-minute neighbourhoods. It's important also to factor in that those with disabilities, older people and the very young may well take longer to walk the same distance. Potential barriers to walking in whatever form, steps, the gradient of the land or the need to cross a busy road must also be weighed. Mr. Hargis points out that the shortest walking routes in Table 1 of the Statement of Common Ground require, for all facilities or services located south of the A127, walking alongside that road and then crossing it. He explains the barrier that that can represent and that it is in any event a very poor quality pedestrian environment and that some walking trips will therefore be discouraged. Further, none of the existing facilities listed can be considered sensibly to be within comfortable or preferred walking distance of any of the proposed houses on site. One primary school, one dentist, and one secondary school, which has no available places at all, are located within a potential maximum walking distance. Clearly, these distances are fixed and cannot be improved upon in the same way that, for example, bus services potentially can. The council's position is that it is reasonable to conclude that for pedestrian trips, the site is not and cannot be made to be reasonably accessible to local services and facilities. As for public transport, clearly the existing 256 service passing along Dunton Road cannot be considered to represent a service of sufficient frequency to support feasible use of public transport. Mr. Wharton agreed that it's scarcely a service at all and can rightly be described as abysmal. Neither are the High Road North and Willowfield services of a frequency that could reasonably be described as regular. Those bus stops are also located considerably further than the Essex Design Guide, recommending walking distances to bus stops, 400 metres, being between 875 and 1280 metres from the proposed dwellings. Basildon railway station is 2.5 to 3 kilometres away, greater than the maximum potential walking distances. Mr. Hargis stresses that if the development goes ahead, there will therefore need to be a significant improvement in bus provision to service the site in order to make sure that it can attain an acceptable level of public transport accessibility. That would indeed be crucial, as currently the Dunton Road service runs once each way, only 3 times per week, and so cannot be used regularly to go to work or school or out in the evening or indeed to anywhere very much at all. Certainly none of the residents who spoke on the first day of the inquiry said that they ever use it. On the contrary, they stress that in living where they do, one has to have access to a car or else be physically and socially isolated. Mr. Hargis noted the proposed financial contribution to be put towards improving the bus service, but could not be clear at present as to the confirmation of its proposed route, frequency and time period. In fairness, there seemed to be something of a consensus in the inquiry that a 7 p.m. end for the service, in addition to nothing on Sundays, was too early and would take away certainty for some who might otherwise have used the bus to go to and from work, as well as obviously providing no evening service. Further, Mr. Hargis's very reasonable fear is that the improvements may not run for the lifetime of the development if it is decided after the initial pump priming period that it is not commercial to continue. We simply cannot be reassured of these matters due to the way that we are told Essex County Council works. What is clear, however, is that for whatever reason, the County Council has signed up to a statement of common ground which does not indicate a proper thinking through of its own guidance in relation to walking distances. Mr. Hargis is right in pointing that out. Mr. Wharton did not argue against the suggestion that the inquiry put aside any further reference, in particular, to the distance thresholds used by the Department for Education to decide when a local education authority must pay for a child's transport to school. These are relatively great distances, bearing in mind the age of the children specified, but in view of the financial focus, this is unsurprising, and it's submitted that the thresholds are therefore of no real assistance when deciding this main issue. It cannot sensibly be suggested that an 8-year-old child, theoretically, walking 3 miles, or rather just under that, of course, to and from school each day is indicative of that child living in a locationally sustainable location. And Mr. Wharton specifically said that he would not expect anyone to walk that distance to school. The inspector probably has a very clear note of the various walking distances rehearsed during the course of the evidence, and they are plainly set out and referred to in the written proofs of Mr. Wharton and Mr. Hargis. Suffice to say, most distances are at the preferred maximum rather than desirable or acceptable. And an unhelpful conundrum also presents itself. The closer shops, e.g. long distant 1 kilometre, might be walked to, but are hardly adequate for the weekly shop, whereas the bigger stores, like Asda, are at a greater distance, 2.4 kilometres, and so realistically unsuitable for walking or even cycling if more than a few items are to be purchased. It stands to reason that the site was assessed of being of limited accessibility. Conclusion, the scheme would inflict substantial harm on the openness of the green belt and conflict with its purposes of preventing urban sprawl and safeguarding the countryside from encroachment. Very special circumstances do not exist to allow the approval of this inappropriate development. The factors which weigh in favour of the scheme are not sufficient to clearly outweigh the harm it would cause. The council therefore invites the inspector respectfully to dismiss this appeal.
Thank you, Ms. Ollie. Over to you, Mr. Dadds.
Perhaps just a point of clarification. I think reference was made to Mr. Richards, but I think that must mean Mr. Reynolds during the closing submission.
I'm sure it does.
It does, and I'm really sorry. That's obviously an error on my part.
Sorry, I thought I'd just double check.
You have the paragraph reference.
Throughout.
Oh, it's around.
Throughout, there's a Mr. Reynolds goes down as Mr. Richards.
Yeah, I've done that at paragraphs 40 and 41. I'm so sorry.
I was just double checking.
Okay, thank you very much.
So, thank you, Inspector. Firstly, the residents, I'd like to thank you for the time that you've given them and for them to convey to you their concerns regarding this application. We have set out a closing statement, but we'll amplify as we move along and maybe move along where there's repetition. But obviously there will be some members watching online and hearing their case being set out this morning. The residents don't have the resources that the applicant has, and Mr. Simons has had teams nearly up to 13 on some days, and the council a similar number. We residents come here unfunded, just trying to do our best, and I think they wanted to make sure that's clear, but they shouldn't be underestimated in their views and passion, and also the evidence that they give. The residents believe the site is in a location which is not sustainable. The proposal fails to make adequate provisions for additional needs for local services, amenities, infrastructure arising from the development. The proposal would not be, it would be inappropriate development in the Greenbelt in terms of land use, location, and regard to the local plan save policy and the national policy framework, the development impact on the openness of the greenbelt, and for the purpose of the included land in it, the effects on the development and its scale, amount to landscape character and visual amenity of the area will cause substantial harm, and the benefits of the development do not amount to very special circumstances to justify inappropriate development in the greenbelt, and therefore the proposal is in conflict with the policy BAS GB1 of the LP and the framework. There is also reference paragraphs. Let me just turn up to that. It's clear. Paragraph 16 of the closing statement, which is BAS BE 12I, and the other paragraphs mentioned there. The much has been said about the scope of which the local authority may raise concerns. The Rule 6 party have raised, and rightfully so, the landscape visual impact review. And Inspector, you'll recall asking Mr. Reynolds a question about that. You asked about the LVIA report, and he directed you to the report and said in 2023 as the most specific, stating it was site specific. It was a review on baseline evidence, views, etc. So that was a question that you asked, and that was the answer he gave. The local residents asked a number of questions about what do you think about if the development went ahead on adversely impacting the landscape. He said in response that he wasn't there to talk about that, but Miss Williams raised the point that the Rule 6 party were, and that he concluded then in answering the question that it would add adverse harm, substantial adverse harm. Conclusions in his report he was asked and shown, and does he stand by that, particularly page 9 and at the bottom paragraph. Do you agree the characteristics would negatively impact and that whether they are the key characteristics of the area? And he affirmed and agreed that they would have negative impact. Overall, based on the particular view, i.e. the LVIR, which is site-specific, do you, in your professional opinion, believe it would have significant adverse impact? And his reply was, landscape and visual perspective, I've concluded that there will be a substantial adverse impact. The residents are of the view that there would be an impact. Now, in relation to the sustainability, I just wanted to add that into that section there, if you didn't mind, Inspector. But in relation to the sustainability, we've set those out, and we say that the site is not sustainable, and setting out that the new houses would be 1 to 1.5 miles from Leighton town centre. To get to local schools, you'd need to necessitate to cross the A127, and that realistically, as you've heard about the lived experience, all the local amenities fall outside the distance which one could reasonably expect to walk. And I understand that you have undertaken some of those, the exercise of walking and so on, getting your steps in for the day. We've heard about the bus service, so I won't comment any more than you've already heard, and we concur that in effect the development it's unrealistic to expect future residents of the development to walk, cycle, take the bus and use services, and we of the same view. Now, in relation to the Greenbelt, I've set those out in paragraphs 5, 6, 7, and they are a repetition of the opening statement, but in essence confirming the same view. The paragraph 6 talks about the fundamental aim of the Greenbelt is to prevent urban sprawl by keeping them permanently open, and the essential characteristics of Greenbelt are the openness and their performance. And that you had evidence from Mr. Chard, and he talked about, and sorry for the repetition, but I think we need to go through this, has a greater affinity with the urban edge of Basildon than that of the open countryside. And obviously, if you recall, I did show this plan showing the yellow with the countryside and the area, and he accepted that. Now, we don't agree that has greater affinity with the urban edge, and that I think further on he makes certain reference about that. But you went to the site visit, as I understand, and you would have seen either a deer or a muntjac on the land. Muntjac, was it? Yeah, and I've not seen one of those in a housing estate, an urban a piece of land ever. You may, but the reality of it, it's in the field, it's in the countryside, and that's the lived experience. You see it for yourself, and so we don't agree that the site is more affiliated with the urban area. It is in effect countryside. He talks about that this is a discrete parcel land that's close relationship with the built-up area in than the open countryside. That's my view, but our view is different to that. Is that it is open countryside, and that's where you saw the wildlife there. He does go on to say it's more aligned with the built-up edge than it is with the open countryside to the north, which has got a completely different character because it's more an open prairie land as you go northward, west, and you've got the plot lands to the north, which is distinctly different in character. So we are of the view that by your experience of going there, seeing the wildlife, seeing how it is in its form, assist you in understanding what we understand, the residents believe it is. I did make a comment about this, and I think it might be relevant if I take you to paragraph 22 of the closing submission, do it this way. We wanted to try to express this, that in relation to expert opinion, we understand it is to be admissible. It must be able to provide the planning inquiry with information which is likely to be outside the inspector's knowledge and experience, but it's also be evidence which gives the planning inquiry the help it needs to form its conclusion. We say members of the association believe that they have given clear and cogent evidence which sets out their lived experience of the location, its social and environmental sustainability. The location is heavy car dependent, and the lived experience that you need of the motor vehicle to do the school run, after school activities and clubs, and for accessing local shops, doctors and places of worship, i.e. Local facilities and services. And the reason why I took you to that is because I don't think, certainly you've heard from others outside giving their theory or their opinion, but we know that you're independent. You're very experienced as an inspector. You'll go to the site. You've seen it for yourself, and the residents are equally giving their opinion on what they experience, what they see, and obviously you'll weigh that up. But I mean, the residents' view is that you don't need an expert to see that its value, its intrinsic value to the countryside, the openness, and that the harm that it will be done to the landscape and visual impact as a result. And you are not assisted by the experts because, in essence, the residents have explained what they believe, and also you've been to the site yourself and seen it for yourself. And that's a view of the residents. Now we set out paragraph 7 and 8, and 9, the summary of the different views and landscape that will be affected. And we've set out 10 and 11 regarding the openness and the council's view. Obviously, they've done a closing submission, so that may have changed somewhat. Number 12, in the residents' view, having regard to the lack of built development on site and the overall size and scale of development proposed, the appeal scheme would inevitably have a greater and harmful impact on the openness of the greenbelt. It would therefore be inappropriate development, which is by definition harmful to the greenbelt. and therefore this should attract very substantial weight. Now, the very special circumstances, we've set some of those out, whether there are, and I ask you to read those and take those as read. And in relation to the policies, as I've just set out in the opening paragraph 16, I will just read that out, that there are, these are not minor adverse effects, whether one applies to the Basildon Local Plan Safe Policy, BAS B12, or paragraphs 20D, 30C, 174D of the MPPF, significant weight should be given to the harm of the local landscape character and appearance, and that BAS 12, BE12 of the local policy sets out the development which results in harm to the character surrounding area, i.e. street scene, etc., landscaping will be refused. Set that against the benefits. And I've set out the weighing exercise, and I understand that the local authority have been doing the scales and trying to weigh the scheme. We say that the harms set against the harms of the benefits of the scheme, the principle of marketing affordable housing, the council's 5-year supply, we know it's 1.85. The residents accept that there's significant shortfall in the supply of deliverable sites over the 5-year. In light of this, substantial weight can be contribute to the appeal scheme, but would make the supply of houses in the district over the next 5 years. While there will be other benefits arising as well, these are far lesser than the provision of housing. We understand the council said he wants to build faster and to have higher standards for house building, but the council expects house builders to do their part and build as quickly as possible. And the residents are quite clear about their view. It may be not the formula, but they certainly want to express it, that the council, whilst the council will be criticised, and I know my learned friend did at the beginning of the on the opening, and will do in the closing, I'm sure, be highly critical of the local authority for its land supply. We'll also talk about the waiting list and housing, and you know the reality of it is that there are have always been certainly for many years thousands and thousands of people on that waiting list, and that those that are in most need are prioritised, and that of course they may not have access, but obviously it will be specific, may not have access to affordable renting provision because of their individual needs. But in any event, the affordable housing is not for the want of identify the lands of land for homes in Basildon. In fact, Basildon has brought forward 2,322 specific homes identified as deliverable within the next 5 years, and has given further 4,487 permissions for homes. But the council says it cannot count these because the developers are not going to build out these sites within the next 5 years. The council is caught between a rock and a hard place, granting permissions on one hand and the developers not building out on the other hand. The council is being criticised for not having enough deliverable sites over 5 years. This shows that planning permissions is not the primary stumbling block to getting homes built, but developers not developing. More new homes are undeniably needed, and we ought as a society encourage and prioritise previously developed land, urban land, brownfield sites first, and protect and enhance green spaces that are critical for tackling climate emergency, safeguarding our precious and fragile countryside and greenbelt next to urban areas that are essential for our well-being. Because we know that the local authority are going to be criticised, but I think that it's a wider problem, and we've heard from the local authority this morning that it's more of a national crisis, and that there are lots of different arguments of why land is not coming forward and why people get outline planning permission or planning and don't deliver. Other considerations, we want to just say this, that the appeal site had been promoted for development through the emerging local plan and was identified in the Greenbelt topic paper, as we understand it, 2017 as one that had potential for housing. However, this document does not, to the residents' knowledge, form part of the adopted development plan for Basildon, but was part of the evidence base for the now withdrawn Basildon Borough published local plan. That was the emerging plan for 2014-2034, and therefore limited weight, if any, should be given to it. This evidence base was not tested through the examination process. Moving forward, a new local plan, the council officers acknowledge that it is possible that land will be removed from the greenbelt, and obviously that will be a decision I expect for the planning authority if there are exceptional circumstances, notwithstanding greenbelt, as I understand it, is a relevant constraint in order to provide for a 5-year housing supply. However, the process for this is at an early stage, and sites, including previously considered suitable, will need to be considered on the basis of a proper evidence base through examination. Therefore, no weight should be given to this consideration as part of this appeal. And I've already covered 22. Finally, there is a potential harm to the green. Is the potential harm to the greenbelt by reason of inappropriateness and the other harms resulting from the proposal clearly outweigh by other considerations. In the residents' view, it's not. Whilst they are not shying away from the very real need of homes in Basildon, the residents consider the appeal scheme to be a major intrusion on the greenbelt, causing substantial harm to the purpose and openness of the greenbelt and significant harm to the landscape character and appearance. Accordingly, remains that the opposed to the appeal. I will just finally add some of the points that I've just made about the lived experience. We have already seen and heard about walking distances, and as we say, taking children, I think we heard from Essex saying that up to 3 miles for a 8-year-old walking to a primary school. But even the distances that we are talking here, someone walking to and back from school, because a parent, as we've given in our evidence, the parents would not allow an 8-year-old to walk along the A127 and across that bridge. And so we're of the view it is not realistic. I know my learned friend will tell us that we can cycle, we can walk. We can all go to the Ferrari showroom and buy a Ferrari, but can we? And the reality is that the real lived experience is that this site is not sustainable, that the residents that currently live in that development within Steeple View and the Resident Association are car dependent. And we talk about the effects on social exclusion. People, if you haven't got a motor vehicle, you will be socially excluded if you live on this site, this proposed site. And that the effects on school, after school clubs, activities in the evening, all those have to be done with a motor vehicle in our grateful submission, a respectful submission. We ask you to refuse this scheme.
Thank you, Mr. Dadds.
Mine's been sent to
Yeah,
you.
I just need to open it. I haven't opened it yet.
It's also been sent to everyone else and will go on the website.
Yes, I've got that.
Lovely, thank you. For the many documents before you, Madam, the issues in the appeal are simple. The most important points are all agreed. In particular, the Council agrees with us that if you find that the scheme's benefits clearly outweigh its harms, you should allow the appeal. And even on the Council's case, taken together, and I'll be coming back to this, the scheme's benefits are now said to outweigh its harms. The adopted local plan is from another era. The basis on which its countryside and greenbelt boundaries were drawn up, we agree, with the Council's completely and indeed substantively out of date. The Council's best case projection is that a new plan is at least 4 years away. Again, more of that in a moment. The shortfalls in both market and affordable housing delivery in Basildon are acute, persistent, stark, and contributing to real world harm. And in relation to affordable housing, as I say in the footnote, Mr. Hargis confirmed his view the delivery was very poor, extremely short, and indeed a major concern. The council's most recent housing delivery test score is the 7th worst in the country. The council has failed to meet important government objectives. Mr. Hargis accepts that there's no effective plan-led system within the meaning of paragraph 15 of the framework. In Basildon, he accepted that an insufficient number and range of homes to meet present and future needs is being delivered in line with paragraph 8b of the framework. We agree that for the council to actually start addressing its housing needs now, the challenge cannot be met through the plan-led system. He agreed, Mr. Hargis did, that those needs have got to be met through the development management process. Again, we'll come back to that. But we agree that the release of greenbelt land has been shown to be inevitable by the extensive evidence base which supported the recently withdrawn local plan. That demonstrated that housing needs in this area simply cannot be met on brownfield land alone, not even close. And we agree that no evidence has been prepared for this inquiry to suggest otherwise. Council accepted in the end that the proposed development is not in conflict with either policy GB1 or policy BE12 of the local plan, contrary, of course, to what had been said in the reason for refusal. We agree with the council that the scheme has at least substantial benefits. Of course, we say they're very substantial, but the council says they're substantial. The council accepts that at least substantial weight should be afforded to the scheme's provision of market and affordable housing. And of course, our case is that these benefits should be afforded very substantial weight. More of that later. There are no character and appearance or design objections from the council. While we agree there'll be at least some harm to the green belt, Mr. Reynolds agrees with us that the appeal scheme will not compromise the Greenbelt's wider strategic function in this area. The scheme will deliver a much needed substantial improvement to public transport infrastructure. There are no sustainability objections in relation to cycling. When it comes to walking, we agree that development will offer a choice of transport modes. You can see the footnote debate is whether it's a genuine choice, and we'll come back to that in a moment. And finally, we agree there are no technical constraints to delivery in respect of highways, heritage, ecology, air quality, drainage, flooding, or indeed anything. In the end, if this council ever wants to start meeting its shortfalls, not of tens or hundreds, but of thousands of homes, thousands, and this is exactly the sort of scheme it's got to start approving. The council itself accepted this reality by promoting this site for allocation until as recently as February of last year. An obvious and important fact, not mentioned even once in the council's closings. And of course, its office has recommended this scheme for approval not once, not twice, but 3 times. In the end, we're dancing on the head of a pin. The council accepts our scheme's benefits outweigh its harms, just not clearly so, whatever that means. And it accepts that there'll be a choice of transport modes within the language of 105 of the framework, but not necessarily a, quote, genuine choice. The truth is the distance between the main parties' cases as this inquiry closes is tiny. First then, the plan-led system in Basildon, it has failed. This part of Essex has been let down by the planning system. Years go by, decades pass, national policies come and go. But through it all, this council's managed to keep its head buried firmly in the sand. There's been no strategic review of Basildon's greenbelt for decades. New plan making exercises have been tried. They've failed. And for too long, Basildon has been frozen in aspic. National policy, of course, expects the review and amendment of greenbelt boundaries to happen through a local plan process, which is to say at least every 5 years, so that needs are properly accommodated. But here, the boundaries around Basildon, the greenbelt boundaries, have been fixed for over 30 years. The Basildon local plan, of course, adopted in 1998, a plan period that ran to 2001. The greenbelt settlement boundaries in the adopted plan are even older, fixed through the Essex structure plan, which dates back to 1982, 41 years ago, 3 decades before the first MPPF. It comes as no surprise then that Mr. Hargis accepts that the most important policies for determining the appeal, including those which prescribe the greenbelt boundaries, are deemed out of date, yes, but not only are they deemed out of date, they're substantively out of date too. The greenbelt boundaries were drawn to accommodate the needs of a different generation in a totally different local, regional and national policy context to the present day. And that, of course, has a bearing on how much weight they can be given. Mr. Hargis accepted all of that. in cross-examination. A new plan for Basildon was, of course, submitted to the Secretary of State for examination in 2019. And through the plan, the council proposed that swathes of greenbelt land be released. Of course, 63% of the district is within the greenbelt. That covers everything outside the urban boundaries, as the plan that I've included shows. Housing needs simply can't be met in Basildon without the release of land from the greenbelt. This wasn't, Mr. Hargis, to be fair, accepted this, inevitable if one has regard to the extensive analysis from the council which supported its now withdrawn local plan, and there is no subsequent evidence, as again he confirmed, which has been published to suggest anything different. This site was among those the council intended to release from the greenbelt for housing. In that plan, the council's own evidence base, which supported the proposed allocation, has demonstrated over the course of many years that this site is appropriate for significant residential development. Another fact which, remarkably, the council's closing submissions do not mention even once. The council's 2013 Greenbelt study identified this particular site as part of what it called a, quote, primary area for development. It noted that the area is heavily surrounded by major infrastructure. It noted that Dunton Road now forms a more definitive boundary in this area than the A127. It noted that the open areas in the north beyond Dunton Road form a clear separation to where the countryside begins. The council's Greenbelt topic paper noted that as the site is set against a pattern of development which does extend further west to the south of the A127, any resulting harm in relation to urban sprawl is not significant. It also considered that development of this site would be less harmful in relation to the countryside than sites located in, quote, more rural locations, that landscaping design and layout could minimise any harm to openness, and that ultimately, whilst some, quote, localised harm to the countryside would arise from its development, quote, the remaining greenbelt in this location and to the north will continue to function as currently in its purposes. That position was confirmed in the 2018 Housing Options topic paper, and again in 2021 when the council's Housing and Employment Land Availability Assessment, the HELA, found that this site was suitable, that it was available, and that it was achievable for residential development. Now, in February of 2022, the plan was withdrawn. Nonetheless, Mr. Hargis confirmed his view that following the approach of the Kennel Lane inspector, it's appropriate to give considerable weight to the evidence base which underpinned that plan. And of course, that evidence base led to this site being proposed for release from the Greenbelt and allocation for housing. Again, as I've said, not something to which the council's closings refer at all. But what about the future? Well, we're now told that the council doesn't expect to adopt a new plan until, at the earliest, the end of 2027, 4 years from now, almost 30 years after the local plan was adopted. The council recognises that there are, quote, several factors which may impact upon its ability to keep the timetable for the production of the local plan, including changes to national policy, guidance and legislation, we've certainly got some of those, and, quote, changing political priorities. And so Mr. Hargis accepted the council's projection for adoption by the end of 27 is not set in stone. Far from it. We've got no idea if, or indeed when, a new plan will be adopted. It could be many, many more years from now. We live in hope. The plan-led system has failed in Basildon. There is no framework for addressing the borough's housing needs. The consequences of the council's failure to plan are serious, and indeed those consequences are agreed. The scale of housing shortages are staggering. We'll come back to them in a moment. Mr. Hargis rightly accepted that they are substantial and very poor. We know, and again Mr. Hargis agrees, that if this borough's housing needs to be met, then the only up-to-date evidence on this question shows that the use of greenbelt land is inevitable. It's not a choice, it's a certainty. There's literally no other option. We know that there's no prospect of a plan-led solution to the problem in the short to medium term. Mr. Hargis accepts the housing needs would have to be met instead through the development management process, through planning applications, indeed through appeals, just like this one. So we turn first to our benefits, and they are very substantial, starting with affordable housing. The numbers in Mr. Stacey's evidence tell a dreadful story. The council didn't rebut any of that evidence. Over the last 8 years alone, the council's accumulated shortfall of 2,640 affordable homes against its needs. There have been on average 22 affordable homes delivered every year in that period, 22, which amounts to 5% of total completions. Mr. Stacey rightly highlighted that the situation was urgent and drastic. Mr. Hodges agreed that affordable housing delivery was, quote, a major concern, which of course it is. As Mr. Stacey's evidence shows, at the current rate of delivery, it's inconceivable the council will address its staggering shortfalls. He estimates there'll be a net addition of only 79 new affordable homes a year over the next 5 years, compared to a net need for affordable housing, which is 597 every year, based on what's called the Sedgefield approach. Mr. Hodges accepted this as a poor position for the moment and indeed for the foreseeable future, i.e. the next 5 years. The situation's not getting better, it's getting much worse. And these shortfalls have real consequences for real people. Those on lower quartile incomes now need over 11.5 times their annual income to buy a home. That's a 41% increase on the position only 8 years ago. Affordable housing delivery has failed to keep pace with identified need on the register by a considerable margin for every year since 2014 in Basildon. Of those 8 years, the number of households on the register has increased by 122%, currently stands at over 1,600 households. Each property in Basildon, which does become available, each one is attracting hundreds and hundreds of bids from people desperate to get off the waiting list and to make their lives in this area. Now, it's easy to get lost in the numbers, but as Inspector Young reminded us in the Oxford Brookes decision supported by the Secretary of State, each one of those households on the register represents a real person or a family in urgent need who have been let down by a persistent failure to deliver enough affordable houses. And the same point was made by Inspector Woodwards in the Maitland Lodge decision in this borough, which was last year, when he said that each of the affordable homes that should have been built but have not represents a missed opportunity to help alleviate the housing concerns of individuals and families. The people who lie behind the numbers in Mr. Stacey's evidence are some of the most vulnerable in our society. The inquiry has not heard from them. In recent years, the Secretary of State's made his view on this issue clear in a series of decisions in Greenbelt authorities, with the plan-led systems not delivered on time, including the case in South Oxfordshire, to which I've referred already. He's given the delivery of affordable housing, and for that matter, market housing, to very substantial weight, and indeed has found that it clearly outweighs harm to the Greenbelt, carrying the balance at 148 of the framework. Last year in the Maitland Lodge appeal here in Basildon, Inspector Woodwards recognised that the abysmal, acute and persistent shortfall of affordable housing represented a significant conflict with the economic and social overarching objectives in the framework. He said, given the critical situation regarding the affordable housing delivery in the borough, he afforded the scheme's delivery of 21 homes, of course, many fewer than is on offer through our scheme. 21 homes, very substantial positive weight on all of the proposed affordable homes, not just those over and above policy requirements. And in the Kennel Lane decision, Inspector Dillon considered that that scheme's delivery of 72 affordable homes in Basildon would, quote, contribute significantly to addressing the existing and predicted very serious housing shortfall within the next 5 years, to which he accorded considerable weight. Our scheme would deliver 40% of its homes as affordable. That's 108 homes, which is agreed to be significantly over what the policy requirement actually is. Mr. Hodges affords this benefit substantial weight in the balance, taking then a different approach to that of Inspector Woodwards and Dillon in the appeals to which I've referred, despite him accepting that those appeals are directly comparable to the scheme before you, and there's no reason why you should take a different approach to assessing the benefits of housing delivery. He did appear, Mr. Hodges, no doubt inadvertently, to downplay the extent of the shortfall in Basildon, relying strangely on a forecast of future net housing need to suggest that the critical situation described by Inspector Woodwards was exaggerated. And in doing that, he repeatedly conflated two different things, which is to say net future need versus actual historic delivery. But it matters not. And it's not even mentioned in the council's closings, because in the end, there's little left between us on affordable housing, only whether very substantial weight should be accorded, as we say it should be, or substantial, as he says. And the real tell is that the council says a general, quote, substantial shortfall in housing delivery, general, to which substantial weight should be attracted, quote, has to be acknowledged. That's what it says in its closings. That's it. A single sentence. It does not address the chronic and acute shortfalls of affordable housing delivery in particular, and the concomitant weight this scheme's offer for affordable homes should attract anywhere at all in its closing submissions. Not a word. Market housing. It's common ground that the council obviously doesn't have a 5-year housing land supply. We agreed that it stands somewhere in the range of 1.46 to 1.85 years. On the council's best case, its shortfall over the next 5 years is 3,936 homes. It's a shortfall of 3,936 homes and the next 5 years on the council's best case. And in our case, it's even worse, 4,433 homes short. Those numbers, of course, are all measured against minimum targets, which is supposed to be a floor, not a ceiling to delivery. Of course, the councils also failed the most recent housing delivery test, not by hundreds, but by well over 1,000 homes, a score of 41%, seventh worst in the country, and was lower indeed than the score the year before, which was 45%. Mr. Haar just agreed that the shortfalls looking backwards are very substantial. He accepted that until the council is able to adopt a new local plan, housing supply is not going to get any better. He agreed that if the council does not consent to development in the meantime, the situation is only going to get much worse. And it's not, with respect, good enough for the council to assert in its closings at paragraph 6 that housing shortfalls prevalent throughout the country. Quote, we have a nationwide problem. The agreed numbers show that there is a particularly stark, bleak, acute, and chronic problem with the housing land supply position here in Basildon, and it requires addressing urgently. Mr. Hodgest agrees that this means that some of the most important central government objectives are not being met in Basildon. The imperative in the framework of ensuring that a sufficient number and range of homes are provided to meet the needs of present and future generations. The objective in the framework at 60 of significantly boosting the supply of homes, and indeed, of course, the requirement at 74 for councils to demonstrate a minimum 5-year housing land supply. The truth is that in this borough, the framework's objectives of addressing housing needs in a plan-led way have been failed. It failed many years ago. This scheme would deliver 269 new homes within the next 5 years. That's an important benefit. It's one that Mr. Hodges gives substantial weight, given the scale of the crisis in Basildon. Mr. Fisher affords it very substantial weight, and he's right. See the approaches at Maitland Lodge and Kennel Lane. Other benefits. Mr. Fisher explained there are a range of other things to be weighed in the balance, including economic benefits, which should, just as the framework suggests, be given significant weight, and the benefit of a 10% biodiversity net gain, which exceeds both local and national policy requirements, which should be given a significant weight. The council argues that as net gains for biodiversity will be required by future legislation, limited weight should be attached to them. But of course, only last week, the High Court held that that approach was wrong in law, because the legislative requirements don't apply retrospectively. Any degree of biodiversity net gain which exceeds current legal requirements should be afforded due weight. And to be fair, Ms. Ollie doesn't go into this in the council's closings. The same applies to the benefit of gas-free housing, which the council gives only limited weight, citing regulations that are only going to come in 2025. I do, just for completeness, give a little summary of the case that I'm referring to in the footnote, which I won't read out. I've shared it with Ms. Ollie in advance of today, and it says what it says. But if you've got any questions, or if you'd like a copy of the case, we can obviously send that in via the case officer. Next, the scheme will sit comfortably within its local landscape. The appeal site is on the northwestern edge of Basildon, obviously. It is bounded to the south by the 4-lane carriageway of the A127, beyond which is new residential development, to the east by existing residential developments in Steeple View, to the west by Steeple View Farm, to the north by individual dwellings, and indeed Dunton Road. Mr. Chard assessed that these urbanising features give the appeal site a greater affinity with the built-up edge of Basildon than with the open countryside which extends to the northwest, and it gives it therefore a, quote, urban fringe appearance or an urban edge character. Dunton Road forms a definitive boundary and provides a clear separation to where the countryside begins, and that of course was acknowledged by this council in its own study from 2013. The site's agreed not to be subject to any national or local landscape designations, and it's not a valued landscape within the meaning of the framework. Mr. Hargest agreed that this is what he called an edge of urban location. Mr. Reynolds preferred to call it peri-rural with urbanising influences. The council has not taken a freestanding landscape character or appearance objection. It's not taken a design objection. It's clear from the reasons for refusal, and Mr. Reynolds confirmed it in cross-examination. He confirmed that his evidence was limited to greenbelt openness and purposes. Obviously, I'll come back to that in just a moment. But in any event, Mr. Chard explained that the scheme can be accommodated on this site without any substantially adverse effects on landscape features, on the site's character, or on its surroundings. And it's not just him who's saying that. It's corroborated by Mr. Reynolds in his LVIR document. And he concluded that the site is, quote, generally able to accommodate development without suffering detrimental effects on character. It has, as he described it, few elements of value. He said that a number of residential dwellings could, he said, assimilate within the landscape surroundings with appropriate landscape mitigation in place. And that's both talking about the eastern part of the site and also the western part of the site, quote, without suffering detrimental effects on character. Quote, development in this location can form an appropriate extension to Steeple View to form a stronger edge to the green belt. And finally, that he found any visual effects were generally localised and can be mitigated to reduce the significance of effect. We agree. The committee report also concluded that development of the appeal site would only result in some identified local harm, but that appropriate landscape mitigation would mean the site could be accommodated without significant harm to the wider landscape. And again, we agree. Accordingly, the landscape proposals include substantial buffers along the southern and northern boundaries, acoustic mitigation fence along the A127, and of course the landscaping scheme in the northwestern part of the site, which is more open to views to the countryside, will be controlled by a scheme to be submitted under a planning obligation that you've looked at this morning. These strategically located open spaces are designed to respect the open views to the north and northwest. The proposed tree planting by year 15 will contribute positively to local landscape character and offset adverse effects caused by the loss of openness. Mr. Chard's LVIA methodology was drawn from the structured approach required by Glivia 3, as well as Natural England's landscape character guidance. And of course, he sets that out in the LVIA. Mr. Chard undertook his own assessment. It was site-specific. Mr. Reynolds did not. He didn't prepare an LVIA. He didn't adopt a similarly structured approach. The LVIR he relies on is, of course, not an LVIA. It's broad-scale landscape appraisal produced as part of a commission to look at lots of sites. Mr. Reynolds does not reference his own LVIA methodology. And with respect, Mr. Chard's the only robust landscape visual evidence you've got before you, madam, and so his conclusion should be preferred. In the end, this scheme would have only minor effect on landscape features and surrounding landscape character, moderate effects on the landscape character of the site itself, and by year 15, the effects of landscape features are expected to be of a minor, moderate, beneficial effect, while the effect of landscape character on the site itself is minor and negligible so far as the surrounding landscape is concerned. And in the end, just as Mr. Reynolds thought, this scheme will assimilate comfortably into its local landscape. Next, the site is in an accessible and sustainable location. There's very little between the parties on location and sustainability. We agree the site will provide acceptable cycle access to facilities, services and places of employment. So that's that. We agree that public transport can be made acceptable for improvements to existing bus services. We'll come back to that, subject to Section 106 obligation that you've looked at. The site can meet the requirements of 105 of the framework in respect of cycling and public transport. We agree there's no definitive standards within national policy for acceptable or indeed maximum walking distances. Several facilities and services are within the preferred maximum walking distances of 2 kilometres from the site. We agree there's no conflict with 111 of the framework. which tells us when you're supposed to be refusing things in respect of transport issues. We agree that Essex's view, as Highways Authority, is that there are a wide range of services within a reasonable walking and cycling distance of the site, and that this is a sustainable location for development. To be clear, the council's case is limited to the site's accessibility of the site in terms of sustainable transport modes, in particular walking, not whether there are sufficient services available to meet any additional need or demand. There's no suggestion from the council or indeed anyone else that the contributions would be in any way deficient in meeting the requirements of the development. So turning first to public transport, at the time of his written proof, Mr. Harger suggested that the proposed bus improvements could in principle ensure that the site achieves an acceptable level of public transport accessibility. But to be subject to further information, he said, on the proposed route, frequency and funding arrangements of the service. Then, at the inquiry, Mr. Harger just had the draft 106 and the heads of terms of what Essex plans to actually do through this transport statement of common ground. He accepted that what was being proposed, what is proposed, is a substantial improvement from what's there at the moment. And indeed, the Reg 122 statement that you've received this morning describes the proposal as a high quality passenger transport improvement between the development and key destinations in Basildon, including employment, retail and leisure facilities. Mr. Hargest accepted that an hourly service is as good as you'd expect. He would prefer a service to be running beyond 7 o'clock. He'd prefer a service to be running on Sundays. He wants guarantees over the identity of the provider and that the service could operate in perpetuity. Of course, no scheme can ever achieve that level of certainty. The County Council doesn't ask us to. Mr. Wharton, in his oral evidence, explained that in his experience of working in Essex for many years, the County Council's standard approach has always been for the final service to be procured and tendered after permission was granted, not before. Mr. Hargest accepted that this is Essex's normal approach. He accepted there's no requirement in national policy to identify an operator now. Longer term management of the bus routes is always going to be a matter for the County Council. It can never be guaranteed in perpetuity through an individual planning application like this one. In the end, Mr. Hargest accepted that provided the bus service was secured as per the 106 and the heads of terms, the site would be sustainable so far as public transport goes within the meaning of 105 of the framework. Mr. Wharton explained how the proposed bus route gives both new residents as well as the existing wider residential population an opportunity to connect to the facilities they would need for work, for travel, for education and for leisure. The new service will provide links to Billericay Station, to Basildon Hospital, to key infrastructure hubs, employment zones, shopping outlets and education facilities. People may choose one form of transport over another, he acknowledged, depending on personal preferences, circumstances, locations. But the key thing is they will have an option. Improvements to bus shelter facilities will allow those with mobility issues to have step-free access onto this bus network. In terms of Mr. Hargest's concerns over the longevity of the route, Mr. Wharton explained that had Essex been concerned about its viability, they could have asked for more money, but they didn't. They sought a level of contribution which is Reg 122 compliant in relation to this scheme and which will, in their view, create a viable service that's going to bring about a benefit, not just to the residents of this scheme, but to many people in the area. Mr. Wharton considered this a good route, which will have the ability to generate enough revenue to make it commercially viable in the long term. Which means really the only area of dispute we've got is in relation to walking. And on that topic, Mr. Hodges accepted there aren't any definitive standards in national policy for acceptable level maximum distances. No explicit guidance is provided in the framework. As Mr. Wharton noted, the Essex Design Guide Mr. Hodges relies on is guidance. It's not a prescription, and indeed it is design guidance. It's not highways guidance. Mr. Hodges accepted that several facilities and services were within the preferred maximum walking distance of 2 kilometres, including the Millhouse Primary School, Willowfields Preschool, Munchkins Nursery, the dental practices, the Steepleview Community Hall, shops at Willowfield, and Fortune of War and the Hemels employment area. Overall, Mr. Hargest accepted that local residents would have a choice of modes to access services and facilities in the area. Now, his issue, as I've said already, was how genuine that choice might be. Mr. Hargest thought it was, quote, debatable. Conversely, Mr. Wharton considers that this choice of transport modes is, and I should say modes rather than mores, is genuine. He confirmed that the Section 106 agreement will contribute footway and cycling improvements, including enhanced crossing positions and junctions. Where walking routes are not suitable for a particular individual, they can still access facilities by cycling, bus or private car. Mr. Wharton reminded us that the appeal site identified was given a draft application within the now withdrawn plan following the appraisal of its suitability and accessibility. This was long before improvements to public transport and the 106 contributions to improve walking and cycling links were actually being proposed. And again, improvements which the Reg 122 statement tells us will provide, quote, key improvements in the vicinity of the site and facilitate links between the development and key destinations in Basildon. In the end, the position is simple. We know from the Highways Authority that the scheme is located in a sustainable location, offering a genuine choice of transport modes where a range of local facilities, services and transport interchanges can be reached by walking, by cycling and by public transport from the appeal site. The council's, the LPA's attempt to undermine the weight you can attribute to the Highways Authority's consistent position, most recently articulated in the Highway Statement of Common Ground, on the basis that they've misunderstood their own guidance, i.e. that is to say that Essex have somehow misunderstood Essex's own guidance. It's, with respect, ridiculous. We also know that the development will contribute to a significantly enhanced bus service along Dunton Road following its procurement by Essex, which is standard practice here. And we also know that in the view of the Highways Authority, the scheme accords with national policy and its ability to promote sustainable transport, that there are no severe residual impacts arising out of the scheme. And they've confirmed, of course, repeatedly that there are no transport, highways or accessibility reasons for refusal. So in the end, just as the Highways Authorities confirmed, there's no in principle issue with the scheme coming forwards in terms of its locational sustainability. And indeed, the council's own officers told members that this is not a reason for refusal that could be sustained. Alas. And as I've said already, there are no other technical constraints in relation to anything. That leaves us then with the green belt. The scheme's impact on the wider green belt will be very limited. Starting with green belt purposes, the green belt serves 5 purposes set out in the framework, and we agree with the council that there's no harm in respect of at least purposes B, D, and E. So we're left with A and C. In his evidence, Mr. Chard reviewed several Greenbelt assessments to better understand the wider Greenbelt context. This included the 2013 study, which found that the wider parcel, known as Area 20, in which the appeal site is located, didn't meet any of the Greenbelt purposes. It found, as I've said already, that Dunton Road formed a more definitive boundary than the A127. The area had potential to accommodate development in its eastern half. That's to say, Area 20 had potential to accommodate development in its eastern half, which would form a strong urban edge to this area of Basildon. Chard highlighted that the 2017 Greenbelt review had concluded that Area 20 contributed to purposes A and to a partial degree purpose C. He queried how that departure from the earlier 2013 study had been arrived at, particularly as recent residential development south of the A127 had only made the surrounding area more urbanised since the study in 2013. But in any event, Mr. Chard considered also the 2018 topic paper, which considered this particular site, i.e. H9. Considered its allocation for Greenbelt release in the now withdrawn local plan. The 2018 study found that in respect of purpose A, this is a site when viewed in the landscape is set against a pattern of development which does extend further west to the south of the A127, so it's not necessarily out of context in its westward extent. So the harm in relation to urban sprawl is not therefore significant when viewed in this wider context, but it could be considered harmful, quote, at a local level. And in respect of purpose C, the finding was that development of this site would be, quote, less harmful in relation to the countryside than sites located in more rural locations. Development would result in, quote, some localised harm to the countryside. That was the finding there. On the ability to mitigate that harm, quote, the use of appropriate landscaping design and layout can minimise the impacts of the development on this site and the openness of the wider greenbelt in this location. And then finally, the finding was, as I've said already, that if the site were developed, the remaining greenbelt in this location and to the north will continue to function as currently in its purposes. Now, in that context, Mr. Chard conducted a site-specific assessment of the contribution that this site makes to the purposes of the greenbelt, and indeed the effects that would arise from the scheme. and he set all of that out in his proof. Overall, he concludes that the site makes a limited contribution towards purpose A, and there's a clear precedent for development to the south of Dunton Road. The scheme does not result in any built form extending any further north or west than current established limits of Basildon. The landscape mitigation strategy and more open northwestern corner of this site would provide a green gateway to provide a visual break from the existing ribbon development and a softer edge to the wider countryside. There's also limited contribution to the third purpose, safeguarding the countryside from encroachment, as the appeal site has a greater affinity with the built-up urban edge of Basildon than the open countryside to the north, and adverse effects can be mitigated. Come on to what Mr. Reynolds says about all of that in a moment, but before we do, openness. Mr. Reynolds accepted that the openness includes spatial and visual components of it. In other words, the perception of openness is relevant in addition to just the volume of built form. Mr. Chard acknowledged that the site will be less open. Of course it will, if new homes are built, which is obvious. The site's currently an open field. Mr. Chard explained that spatial loss of openness, though, would be limited. Most of the new homes, 2 stories and at scale appropriate to the character of the surrounding area. 22% of the site's going to be retained as open space. Much of the development includes things like gardens and driveways that are open. There will be substantial landscape buffers along the northern and southern boundaries, and indeed the western boundary treatment of hedgerows and grassland to maintain an open transition to the west. The existing perception of openness is generally restricted to within the site itself and its immediate vicinity, in particular near distance views from Dunton Road and the A127. Mr. Chard explained that the sense of openness is limited by the site's relationship with the existing settlement edge of Basildon, the busy A127, pylons, high voltage cables and traffic on Dunton Road. He recognised that the loss of agricultural land will inevitably result in some loss of visual openness within the appeal site itself. The effect on the wider area, though, much more limited. Mr. Chard has assessed openness by reference to various viewpoints, and from the locations where you'll see anything at all, your views will be limited to the western part of the site, and any perceived loss of openness is not significant. The harm is likely to be most perceptible along Dunton Road itself, in particular from near distance views. The sense of openness would only be eroded from those views to a limited degree, as green gateways, tree and shrub planting will soften and break up the views from Dunton Road and the farmland to the north. Now, what of Mr. Reynolds's evidence? In Mr. Reynolds's evidence, continued references are made to assessments of, quote, the site. But as we found out in cross-examination, that area, the site, includes a vast swathe of land that extends westwards, all the way down to the A127 West Main Interchange, aka Area 20. The appeal site is, of course, far smaller and far better contained. It's a well-contained corner of that wider area, and of course one which the council's own assessments have assessed as being suitable, available and achievable for residential development. Mr. Reynolds accepted. He couldn't take you, madam, to any document where he had conducted any site-specific analysis of greenbelt harms, and that's for an obvious reason. He'd not done it. In re-examination, he suggested that rather than in his proof of evidence, you should think about his LVIR to consider his case on openness, but that's a non-starter. Firstly, it's not a greenbelt document. It was a review of an LVIA, which was looking at landscape and visual effects. Regardless, where it does discuss openness, it, just like everything else he said, refers to the wider parcel of land known as Area 20. The LVIR does not contain any site-specific consideration of this appeal site against greenbelt purposes or indeed harm to openness. There's nothing. And to be clear, the point at paragraph 12 of the council's closings is wrong. It is said that both the council and the appellant use the LVIR as part of its starting point to determine the impact on visual openness. Well, we don't, because the LVIR does not contain any site-specific consideration of greenbelt openness. Mr. Reynolds' approach to the council's evidence base is equally concerning. In cross-examination, he accepted that the 2018 topic paper was the most relevant document for you, madam, to consider in assessing greenbelt effects. We agree with that. This is the only study, of course, that the council's produced which contains a specific assessment of the appeal site itself, site H9. Despite this, Mr. Reynolds conceded that his assessment of Greenbelt purposes and openness makes absolutely no reference, so no reference at all, to the findings of the 2018 topic paper, which he says are the most relevant ones, and its conclusions in respect to the impact of Greenbelt openness and purposes associated with developing H9. When finally forced to engage with that paper and what it says, when I was asking him questions about it, Mr. Reynolds agreed with the council's conclusions in that paper that some localised harm to the countryside will arise from the development on the site, that the impact on openness to the wider green belt could be minimised, and critically, that the remaining green belt in this location to the north will continue to function as currently in its purposes. All agreed. Another thing he ignored was the 2013 Greenbelt study, asserting that because it was from 2013, it carries no weight at all, he said. He claimed that boundaries and vegetation would have changed since then, albeit he didn't actually know what the land looked like then and has no knowledge of any changes on the ground. But there we are. He makes no such criticisms of the 2014 study or indeed the 2017 study. He looks at both of them, and he accepted that both of those documents looked at Area 20 as a whole, not the appeal side, and stop in place substantial reliance on both documents. Now, it does not mean, as Mazzoli now suggests, that he's managed somehow to understate the relevant Greenbelt impacts by assuming that the appeal site serves the same functions in terms of Greenbelt openness and purposes as a much, much wider area, Area 20. Mr. Reynolds has vastly inflated his judgments on the levels of Greenbelt impact associated with our scheme. It doesn't end there. Mr. Reynolds has also relied on wholly inappropriate guidance to consider the potential impact on openness. It was something you asked him, madam. He argued that Glivia 3 was his, quote, starting point, he called it, for his approach to assessing openness. It's got nothing to do with openness. It's a landscape document. It tells us literally nothing about the proper approach to assessing Greenbelt openness. It's clear why Mr. Chard's evidence on Greenbelt harm should be preferred. It's methodical, it's evidence-based, and maybe most of all, it's site-specific. It stands up to scrutiny. Conversely, Mr. Reynolds' evidence is premised on guidance that's irrelevant, fails to engage relevant evidence that the council itself has produced and doesn't in fact contain any site-specific analysis at all. We cannot simply ignore these flaws. Now, in its closings from 17 to 48, so the first half of its closings, the council makes repeated assertions to the effect that Greenbelt harms on what it now calls, quote, the site, not clear what that means, are, quote, not simply limited. If we're talking about the appeal site, those submissions are not supported by its own evidence because, as I repeatedly said, it has no site-specific Greenbelt evidence. And further, most of the actual analysis from 17 to 48 relates to matters of visual impact, not openness, not Greenbelt purposes, not any part of the council's actual case. To the extent Mazzoli does attempt to summarise Mr. Reynolds' position, it's inaccurate. For example, she says in paragraph 17 that the site, again, you know, whatever that means, clearly plays an important role in preventing sprawl and safeguarding the countryside from encroachment. That's what she says. But again, Mr. Reynolds repeatedly and expressly agreed with the analysis in the 2018 topic paper that says something completely different. It says the remaining Greenbelt in this location and to the north will continue to function as it does at the moment in its purposes. So overall on the Greenbelt, madam, as we know, and indeed as Mr. Hargis agreed, the council requires land which is currently at the Greenbelt in order to meet the enormous and urgent needs that I've already described. The council does not have an effective plan-led solution to manage those releases. It means that an impact on the Greenbelt, one way or another, through development management decisions like this one's not a choice. It's a necessity. It's inevitable. The real issue should be whether schemes can come forward which do not unacceptably impact on the Greenbelt's wider integrity. Now, of course, in the language of Greenbelt policy, this site will be less open if homes are built, obviously. The site is also deemed, quote unquote, countryside. But we should take care over that. The reason it finds itself still deemed as countryside is because it's next to but outside the settlement boundary. But as I've already been over, that boundary is not just marginally out of date. It's the product of a totally different generation of plan making, which means that our scheme would, in the language of the framework, quote, encroach into that countryside, albeit in a very limited way. But the problem is, this is a purpose which will inevitably be engaged one way or another if the council is going to come anywhere remotely close to meeting its needs, recognising that there'll be some impact on openness. And greenbelt purposes can't rule out sustainable sites from bringing development forward, or the council wouldn't have any sites left at all. The 2018 topic paper tells the same story, and I've read out a few times what that says, so I'll pass over A to D as read. Which means that in the end, we know that the site is not one of the most sensitive or important parts of the greenbelt in this area, and allowing this appeal would have a very limited impact on the integrity of the greenbelt. Now, in the end, of course, national policy dictates that these impacts must be given substantial weight. So what really matters in, that should say 148, not 144, that's old money, NPPF paragraphs. What matters in 148 NPPF cases like this is how the final balance should be struck. So we turn finally, madam, to striking the balance. In the end, the position is straightforward. Section 38(6) of the 2004 Act requires you to begin by determining whether the proposals accord with the plan, not whether they accord with each and every policy within the plan, but whether they accord with the plan read as a whole. As Mr. Fisher's observed, there's something of a gap here. Only 4 development plan policies are agreed to be relevant. One's a policy about crime prevention, and we agree that we can accord with that one. Another one's about affordable housing. Of course, we well exceed what that requires. The council's greenbelt policy, Mr. Hodges accepted, does not provide any guidance as to how decision makers should actually determine individual planning applications. It just defines the greenbelt boundaries. Although, contrary to his and indeed the council's original position in cross-examination, he accepted that BE 12 does not relate to the greenbelt. That's a policy all about landscape character. Mr. Hodges therefore accepted no conflict with GB1, and he accepted no conflict with BE 12. Mr. Child's conclusions are the proposals would not cause substantial effects on landscape features or the character of the appeal site, so there's no conflict with BE 12.1. None of the other criteria in BE 12 are at issue, and that was confirmed in the officer's report. So in the end, this is a scheme which accords with the statutory development plan when read as a whole. But the question remains, madam, do the scheme's benefits clearly outweigh its harms? If they do, we agree with the council that you should allow the appeal and grant planning permission. On one side of the scales, you have before you extensive evidence of our benefits. Most importantly, we would deliver desperately needed market and affordable homes in a sustainable location that was proposed for allocation through the council's most recent attempt at adopting a new local plan. Although the council only offers these benefits substantial weight, given the scale of the crisis in Basildon, and indeed consistently with other appeal decisions, Mr. Fisher instead gives them very substantial weight, and he identifies other benefits too, as I've touched on already, BNG and economic benefits and others. On the other side of the scales, madam, there's no credible evidence of harm of anything like that order. The harms are almost entirely limited to the site itself, but there will be some loss of openness within the site. There'll be a very limited degree of harm to the wider greenbelt. If the council wished to dispute that assessment, it's failed to provide any convincing evidence to the contrary. Mr. Reynolds' evidence, of course, is fatally flawed because it lacks any site-specific assessment of what's before you. He's failed to engage seriously with what's agreed to be the most relevant document on the greenbelt effects produced by his own client, a document which itself makes clear that harm to the greenbelt would be localised. The moderate minor adverse harms to landscape character will be limited to the site itself. It could be mitigated to reduce their significance, and that there aren't any other harms. In striking the balance, we must remember that the council's officers have recommended our scheme for approval not once, not twice, but 3 times, noting each time that our benefits clearly outweigh our harms so as to amount to the very special circumstances described by 148 of the framework. We must remember that the council was until recently itself promoting the allocation of our site for greenbelt release and residential development. Again, remarkably, they don't mention that once in their closings, let alone do they address it. Prior to day 1 of the inquiry, the council's case was, coming into this inquiry, that the position is, quote, finely balanced, but the benefits of the scheme should still attract substantial weight. Mr. Dadds for the Rule 6 party in his evidence in chief also accepted that matters were, as he put it, finely balanced. But the council's case has changed. It is no longer that, quote, fine balance that it continues to refer to at paragraph 1 of its closings. In light of Mr. Reynolds' evidence, Mr. Hargest confirmed that if the impact of the proposed scheme on greenbelt openness is localised, and indeed Mr. Reynolds has agreed that it would be, then the overall planning balance shifts. It shifts in favour of approval of the scheme, not, as the council's closings say, the balance might tip in favour of approval. No, his evidence was that in those circumstances, it would tip in favour of approval. Now, Miss Ollie tells us that clearly is the critical word here. Well, if the benefits outweigh the harms, as we now all agree that they do, I say all, us and the council agree that they do, there's nothing unclear about it. The benefits outweigh the harms. The position's perfectly clear. Ms. Ollie refers to, at 3 of her closings, the planning balance, quote, radically shifting in favour of development. That, of course, has this idea of a radical shift, has no resemblance at all to the actual test you're actually being asked to apply. So to be clear, this is a case where the council's own evidence has concluded that the benefits of this scheme outweigh its harms, and indeed, as the council's office has concluded several times, those benefits clearly outweigh any harms. Given the disastrous scale of shortfalls in delivery in Basildon, this scheme's benefits are profound, far more profound, pressing, and indeed substantial than the council even now wishes to accept. The imperative to bring them forward is compelling, and then will clearly outweigh what will only be localised impacts to the appeal site itself and its immediate surroundings. And for those reasons, Madam, the balance and the framework at 148 tilts decisively in favour of granting planning permission, and on that basis, we ask you to allow the appeal. Thank you very much.
Thank you, Mr. Simons. Okay, that concludes the inquiry. We have a date set for the completed section 106 agreement to be submitted if you want it to be considered as part of the inquiry document. So nothing further from me other than to thank you all for your contributions and thank yourselves for keeping the IT working, and I shall pass on also all your thanks to Miss Dyson in the office, who undertakes all the administrative tasks in relation to the inquiry. So thank you, and the inquiry is now closed. Thank you.